we will go ahead and call to order the Property and Casualty Insurance Committee meeting of the annual NCOIL meeting. Since we are kind of in a dual mode here, we would ask that all of the legislators who are participating on Zoom, if you would, please identify yourself.
Kevin Cahill from New York.
Pam Hunter from New York.
Ken Cooley, California.
I didn't.
Neil Breslin,
Neil Breslin from New York. I was on.
George Kaiser, North Dakota.
Bob Hackett, Ohio.
Steve Westfall, West Virginia.
Peggy Mayfield, Indiana. Peggy Mayfield, Indiana.
Good morning, Peggy.
Jim Goose from Kentucky.
Okay, if that's all of the legislators participating by Zoom, if we would, please have the legislators in the room identify themselves.
Representative Mike Weber, Michigan.
Mike Gaskell, Indiana.
Matt Lehman, Indiana.
Paul Etke, Minnesota.
Sean Vita, North Dakota.
And Bart Rowland, Representative Kentucky. With that, I would introduce a motion to waive the quorum.
So moved.
Have a motion and a second.
Second.
All in favor?
Aye.
Aye. And also a motion to adopt the minutes of the previous meeting.
Motion.
So moved. Second.
Have a motion and a second. All in favor?
Aye.
Aye. And the minutes are adopted. All right, we do have a really packed agenda this morning, so we want to go ahead and get started right away with continued discussion on the NCOIL Distracted Driving Model Act. We are going to start this morning with Senator Bob Hackett from Ohio. Senator Hackett, when you're ready, you may proceed.
Yeah, I'm ready. I'm off of mute. Thank you, Mr. Chairman, and thank everyone for joining today. I won't take up much time. I just want to say a few words before we begin and note the changes that me and my colleague and co-sponsor the model, Assemblyman Cooley, have made to the model since we last met in Alexandria in September. The model is in the legislative binders on page 231. A few housekeeping items were made in the form of adding a table of contents, a title section, and an effective date section. We also added a new section 2 titled Purpose, which most importantly makes clear that the model is intended to allow for primary enforcement. Lastly, we made amendments throughout the model to make clear that it targets handheld electronic devices and not in-vehicle technology devices. In Ohio, total claims are down due to the pandemic, but serious accidents are up, and everyone agrees that it's due to distracted driving. I think we're making good progress on the model, and I look forward to the discussion today and hopefully having the model ready for a vote by the next meeting or the summer meeting at the latest. Thank you, Mr. Chairman, and I'll turn it back over to you.
Thank you, Senator Hackett. Next, we will hear from your co-sponsor, Assemblyman Cooley. Ken, I think you're on mute.
Thank you, Mr. Chair. I want to thank everybody for the opportunity to speak to this bill. I think it's a very important one. I think that primary enforcement element is quite vital. And I relate this to the 1980s when here in California, we were looking at enforcement of seatbelt laws as a way to reduce the loss on the highways. It was seen as kind of, how do we feel about this? And we started in California with secondary enforcement. You couldn't stop somebody for a seatbelt violation, but it became apparent it was having a dramatic impact reducing injuries in car accidents. And so in fairly short order, California, having tiptoed around the issue of enforcement, went from secondary to primary, as we've proposed here. Its life-saving impact was apparent to all. And we kind of crossed that boundary of primary enforcement with very little controversy. It's sort of second nature now. And it produces beneficial effects every day. So I think this is the same concept relevant to this topic. I also thank Senator Hackett for the work with differentiating those technologies which are built into a vehicle from the other technologies for which this is a primary concern. Anyway, so a good bill. Thank you very much. Pleasure to join you this morning.
Thank you, Assemblyman Cooley. Our comments next will come from Andrew Kirkner with NAMIC. Andrew.
Good morning, Mr. Chairman and members of the committee. Andrew Kirkner on behalf of the National Association of Mutual Insurance Companies and our more than 1,400 member companies. Really appreciate the opportunity to speak to the committee this morning, and we would urge the committee to adopt the model currently before it. I think the model presents the committee with an opportunity to send a message to those states that are considering distracted driving related legislation. And that message is that NCOIL, which truly is the country's leading insurance legislative voice, is committed to ending distracted driving and saving lives. We spoke in support of this model at the last PNC meeting, so I'll try not to repeat any of those points here. I would just note for the committee what's already been said by the sponsors. We think that the addition of the purpose section, which specifically references a primary enforcement mechanism, is very important and is an improvement to the bill. And then we also would just revisit and again encourage the committee. The model contains prohibitions on watching media or broadcasting media from a car while operating it or from a vehicle while operating it. We think those are really positive developments. In some of the states that adopted early distracted driving legislation, so-called texting and driving bills, those provisions were not included. And so we think that's a real improvement and an opportunity for those states to revisit some of those conversations they had earlier. So I will not belabor the point, but in closing, we'd really like to thank Senator Hackett and Assemblyman Cooley for their hard work on this bill, and we would encourage the committee to adopt the model. Thank you.
Thank you, Andrew. And our final speaker on this topic this morning will be Wayne Weichel, with the Senior Director with the Alliance for Automotive Innovation.
Good morning, Chairman Rowland, members of the committee. Again, my name is Wayne Weichel. I'm here with the Alliance for Automotive Innovation virtually. We are a DC trade association formed earlier this year, representing the manufacturers who produce 99% of all light-duty vehicles on the road each year, as well as tier 1 suppliers and other autonomous vehicle technology companies. Our members have spent billions of dollars to make ever safer automobiles, and the Auto Alliance and its former iterations have worked to support these bills in the states when they've come up. As noted, when this bill first came out, we had concerns that it would unintentionally capture in-vehicle electronic systems within its scope. Why this is important is that in-vehicle systems have been designed with engineering specs to increase roadway safety. We want people to pair their phones with their in-vehicle systems. It makes roadways safer. Things like voice to text, or how you can call up a recent address, but you can't type in a new address from scratch while you're driving. These are things that make roadways safer. These are also things that help to keep drivers' hands on the wheel and eyes on the road, which we think is the most important thing to avoiding unnecessary crashes. We are appreciative of both of the sponsors of this language and NCOIL staff who have worked with us over the interim to see these concerns addressed. And as such, we would strongly support the model law as reflected in the 30-day materials and urge its adoption.
Thank you. Are there any comments or questions from any of our legislators, either in the room or on Zoom?
Can you hear me?
Representative Lehman.
I think maybe Edmund has one as well, but so this is maybe a broader question to everybody that's on the panel and also to the sponsors. whenever we've had this discussion of distracted driving, you know, we so narrowly focus it to the devices. So I'm using my handheld device in my car. Is there data? I know the data that's out there shows that is the biggest reason, but where does this lead as far as, you know, I eat in my car, I've got kids in my car, I've got a lot of things in my car that are going to distract me beyond just my handheld device. So when we go down this path of narrowing this down to, hey, if you have a handheld device and pairing it with the car, and you do all the things you're supposed to do, but then we have, you know, in this case, I know every state's different, and we talk about we build the foundation, not the walls, but you know, we've got about a page and a half of penalties. I'm just curious where this long term, where you think maybe this is going when it comes to other issues that create distracted driving. I'd just be open that up for some answers.
We do have a couple other questions or comments. Representative Jordan.
Thank you. I appreciate it. Look, one, a minor one, just a point of clarification, and then one that is a little bit more problematic for me. On page 233, number 4, I think it says, when they talk about any form of electronic data retrieval or communication, I'm wondering, you know, if we're using Waze or Google Maps or Apple Maps, if that falls under data retrieval. So I just like somebody to give me an answer on that. But the bigger issue for me is switching this from secondary to primary. I can tell you the Louisiana Legislative Black Caucus had a bill like this come up the last several years. And that's been a major impediment for us just because of the impact it could have on communities of color and policing. So, you know, in light of the fact that we just had a meeting dealing with race and underwriting, and I know it doesn't touch directly on underwriting, but I think it is something that I'd ask the authors to consider as we move forward.
Hey, Matt, in answer to your question, first, if you go to 233, look under C. It says the driver shall exercise due care and operate a motor vehicle on the highways of the state and shall not engage in any actions which shall distract such driver from the safe operation of such vehicle. So, and I realize it does get specific with the electronic devices, but it does say that. I don't know if that would come into that, et cetera. That would take over what you want.
Thanks, Bob. And it does in a way, but I think, you know, I guess maybe this goes even to Edmund's point of it becoming a primary now enforcement. So if this were the law, would I be able to stop someone who I believe is distracted by how they're drinking their coffee as they're driving? Because it says, you know, they have to be able to operate safely and engage. And this is kind of one of those, you know, we dealt with this with all the different technology bills we've had and the sharing economies, things like that is where does this have a parameter around, I can do this, but I can't do that. So you're right, Bob, that is in there as far as, you know, there's this, you shall engage in any action that distracts you, but is now drinking my coffee as I drive a primary reason to stop me, an officer to stop me?
Well,
Thank
I
you.
can jump in. Be recognized, Mr. Chair. Ken Cooley.
Yes, please.
Well, I think the state of the law in most jurisdictions is if a officer of the law sees a car operating in an apparent unsafe manner, they can stop you anyway. So we're not actually changing that. And if, you know, I would expect that if a officer observed a driver who has a car full of kids and is turning and looking and talking to the kids and create an unsafe condition, I actually think the officer would feel very impelled to pull that person over and have a conversation, less a tragedy unfold. So I don't think we're really changing the general law of due care of a motor vehicle operator. We are going into this specific area of a new type of peril that gets introduced into the operating of a motor vehicle, which is, we have the law we have because an operation of a motor vehicle is itself fraught with peril, and that's not a knock on manufacturing. That's just to say you getting people involved in moving in a high rate of speed down a thing, and you have collisions, et cetera. So I think in this case, we are focused on a specific new element in the environment. I will say that I think we could work with staff on making clear that we're not really trying to create a class of restating the law of due diligence and driving a vehicle that extends to all other conduct by that C. We're just saying, okay, that is actually the yardstick currently. This is writing sort of specialized rules with respect to the use of technology. And, I think that the problem with secondary enforcement, which I am mindful of the concerns expressed by my colleague from Louisiana, Mr. Jordan. Secondary enforcement is not a perfect solution to that either, because then what happens if an officer thinks they have an issue, then they're looking for some other reason to conduct a traffic stop in order to address the issue of the electronics. And, I think there's a long history of problems with that. Alleged that someone's taillight has an issue, or some would seem to be suspect reason for pulling someone over. I think that the statistics on distracted driving are awfully darn good. And if we haven't adequately established that as a record, then we can do that. I mean, I definitely think this is the sort of bill that would be well served by clear legislative findings concerning distracted driving. And I think we could readily partner with the automotive innovators, the automotive companies themselves, and incorporate that. But again, I mean, as I say, I advised the state assembly on insurance matters in the 1980s when we looked at the seatbelt laws, and people were very nervous about them. But in fact, it is such palpable common sense that it became widely embraced. And I think that's the type of issue we're dealing with here. And I do think it is a distinct class of behavior that builds upon the basic law of tort and the obligation of everyone's duty not to cause harm to others. But it writes the rules in this area of technology in a way that is helpful. That would be a proponent's view, Mr. Lehman.
Yeah, the only thing to add, Matt, is look at the numbers of people that now text and drive and use their phones when they drive. Remember, if you use your phone and you're in your car, you have to look down at it. And when you're looking down in the car, you're actually almost driving blind. And so it's just that the numbers have increased so much with people using their phone in the car, and they just don't realize. Yeah. But thank you.
Thank you. And we have one final question or comment from Assemblywoman Hunter.
Thank you. I'd like to associate my comments with Representative Jordan. I definitely think, there can be instances where models can create unintended consequences, and especially negatively impacting communities of color. So I definitely think that should be something we should always be careful in looking at when creating these models. But I do have a question for the manufacturer representative. I don't remember his name, but on the panel, when is it a manufacturer's responsibility, and I guess this line is very narrow. And he made mention of creating vehicles to make sure that they're safe, and having the engineers to, make sure you can do talk to text, and, syncing the Bluetooth with their phones so people are hands-free. Cars, now have televisions in them. They're like spaceships now. These new vehicles have so many gadgets that, seemingly, while luxury and convenience, I can't imagine an instance where someone's not touching the screen or pushing a button. Back in the day, people were smoking heaters all day, driving down the road, and no one's ever talking about the fact that you have one hand, not on the wheel because you're smoking cigarettes the whole entire car ride. So, I don't know where that line is when we're having conversations with manufacturers relative to responsibility. I know it's comfortable, it's great, it's luxurious, it's got all these gadgets, but it just takes away from the fact that you're supposed to be concentrating on driving. And when you can watch television in your car, I think that line has surpassed. And I don't know, how do you take away from the responsibility of the manufacturer that it's over creating too much distraction in a vehicle? Thank you.
If it's okay with the chair, happy to answer the question.
Yes, sir.
Thank you. I appreciate the insight. And let me start off by, while new automobiles may have video screens available to passengers, there is not a car on the road today that is produced that has a television screen that is capable of displaying entertainment video within the eyesight of the driver. That is, while there may be a video screen, a screen of some sort, but it is displaying other information relative to driving. Where the line is, I think you can understand what automakers see on this when you look at the billions of dollars that have been pushed into developing autonomous vehicles. That according to the National Highway Traffic Safety Administration, 94% of automobile accidents are caused by human error. The pathway that automakers see is that in the future, there will be less and less involvement of the human driver in regular roadway situations. That the path forward ultimately leads somewhere in that area. In the challenge, and part of the reason that we're pushing this legislation is, as I noted, we want people to pair their phones with the car because it does create some controls. In the absence of that, yes, someone could be driving down the road watching YouTube on their phone surreptitiously that they're sitting on their lap or something of that sort. We want consumers to include, to link their phones to the vehicle so that we can block out those sort of things. And as for distraction, everything is, as was noted, everything someone does in the vehicle that is not the driving task could be a distraction. The hope within an automobile is with repetition, I know when I first got a new vehicle last January, first week or so in the car, it took me a little bit to turn the radio station to answer a phone. But now after having it a while, my eyes don't leave the road to turn the station or pick up a call or even set up voice to text. So there's a learning curve, but in the on balance, we keep coming back to that it's better to have vehicle systems that are designed with international engineering standards better than the Wild West of someone just trying to do that on their phone when there's no controls on it.
Thank you. We do have one final question, and then we'll need to move on from Assemblyman Cahill.
Thank you very much. I wanted to echo the comments of a few of my colleagues about the danger of using any kind of enforcement for racial profiling. It's not something that we have to state as a matter of opinion. Study after study has indicated that law enforcement against drivers who are people of color is substantially higher than law enforcement against drivers who are white. That is a statistic that's been proven over and over again, and specifically with regard to distracted driving laws. A study of one police department showed that there were 4 times as many Black people pulled over for distracted driving as there were white people in a community that had only 20% Black people in it. So I doubt very much that people are choosing to use devices because of their race. It probably speaks to the nature of enforcement. And that brings us back to the very beginning of this whole conference this week of the benign and sometimes passive means by which race impacts insurance. If somebody gets arrested or charged with the motor vehicle violation, that puts them in a higher risk category and results in their insurance going up. So I think the points are well taken, and we should continue to consider those aspects when we are looking at all of our laws. That being said, let's stay with statistics for a minute. Distracted driving is more dangerous than drunk driving. It is killing more people than drunk driving. It is causing more accidents than drunk driving. And if you are one of the many legislators who had the benefit of going to the Griffith Institute several years ago, where there was a graphic demonstration of distracted driving, where we all participated with a screen in front of us, and we missed pedestrians because we were intentionally made to distract ourselves, you would understand that this is a serious road hazard that has to be addressed. There's no evidence nowhere, maybe it hasn't been studied, but there's no evidence that drinking coffee and driving, or even, as I used to do, shave and drive at the same time, an electric razor, would cause any kind of accident. It is the distraction of your concentration that's at stake here. And when you are using a device, when you get hung up on a device, you dial the wrong number, you get the wrong information on your screen, you lose your focus and you forget momentarily that you're driving, and therefore it is very important that we do so. So I think it's important that we set as close as we can to a uniform standard across the country, because without laws, people make their own judgments as if it's a matter of opinion. When we make these laws, we do it to encourage behavior, and it certainly has worked. As my friend Mr. Cooley pointed out, look at seatbelts. We all wear them now. There was a time when we didn't. Look at smoking indoors. There was a time when a lot of people did that, and now by and large, it doesn't happen. Behaviors change because we as legislators make rules, and this is an opportunity for us to change the behavior of drivers and maybe make roads safer. That said, I'd like to go back and visit the topics that Chairman Breslin was addressing on Tuesday or Wednesday, whatever day it was. This is a long week. And I think we should be cognizant of those facts when we go forward. So thank you very much, and I support this model act.
Mr. Chairman.
Yes.
Would you mind if I briefly commented on the primary enforcement piece?
Sure. Yes. Go ahead, Andrew.
Thank you, Mr. Chairman. So I would just like to briefly respond to Rep. Jordan and Assemblymember Hunter and Cahill's comments. I think all three of you raised an important topic, and it's one I think that we've seen play out at the state level as well. And that is the effectiveness of primary enforcement as weighed against its potential negative impacts on minority groups. What I would say, specifically as it relates to the model before the committee today, is that the purpose statement puts forth into the model a pretty cut and dry statement, which is that primary enforcement of laws is an important part of the strategy to reduce traffic deaths and life-altering crashes. I think that statement, taken alone, is true, right? And it's certainly something that NCOIL should pursue, in our opinion. The discussion, though, that conversation will not happen in a vacuum. And I think at the state level, there's ample flexibility after passage of this model for states to balance other concerns with that primary enforcement mechanism. And so this is a conversation, much like it occurred in Virginia this past session and several sessions before then. That's gonna come down to the legislative bodies in individual states. I think it's if we look to seatbelts, for example, the CDC cites an age study that shows that states with primary enforcement of seatbelt laws have something like 9% higher use of seatbelts, right? And so it's not a one-to-one corollary, but we know that primary enforcement is helpful, and we know that distracted driving is dangerous. I don't think that's the entire part of the equation. I think certainly states need to look at priorities and enforcement, but I do think that the model would still leave ample flexibility for that process to occur. Lastly, Mr. Chairman, I would just offer there are states that have considered distracted driving legislation that have included as part of the package a discussion on, not a discussion, instructions for the study of enforcement across demographic groups. That may be something that would be appropriate, if not in this bill, in the future for NCOIL to consider. So thank you very much.
All right, thank you all for the conversation. And Will has just informed me that some states that have already passed a distracted driving model have put in their language to study the impact that it might have on minorities. Would it please the committee if we maybe inserted some language like that into the model? Any comments from the sponsors or committee members?
I think it's a great idea.
I'm okay with it. I'm one of the sponsors.
Yes, I think that actually is an outstanding idea. You know, to me, I think the philosophy of the bill, everyone owes a duty to exercise due care so as to not subject others to unreasonable risks of harm. That's the law. This aligns with that. But to kind of put a spotlight on a concern for its equitable enforcement and application, and to set up a reporting system on the use of the statute in a given state is a good idea.
Okay, thank you. I assume Will can distribute some language to the committee and the members before we meet again in March, and it sounds like there still is a little bit of work to do on this model bill. I think it was a healthy discussion this morning, and appreciate everyone's participation. We'll move along to the second agenda item this morning, which will probably be quite lengthy. We do have, I think, 8 folks that are signed up to speak, including the sponsors. So I'll go ahead and get started on the introduction of the NCOIL Coronavirus Limited Immunity Model Act. I am proud to sponsor the model, and it does deal with a very important and timely issue. The model is in the binders on page 237, and it's pretty straightforward, primarily based on what was enacted in Idaho this past summer, although there have been several other states who have already issued immunity type legislation. The model essentially protects businesses by providing them a certain level of immunity from lawsuits related to COVID-19. But of course, if a business acts in a reckless or willful manner, liability can be attached, but the businesses who want to reopen in a safe manner should be provided a certain level of immunity from COVID-related lawsuits. As most of us are following, we know that Congress is considering enacting similar legislation, and if it is indeed enacted, this model legislation may become moot. But nonetheless, I feel like NCOIL should be proactive and be prepared to act if Congress fails to do so. I'll turn it over to the co-sponsor of the model, which is Indiana Representative Matt Lehman, our president, for some remarks and also some thoughts on that he has on how we might proceed with this model act. Representative Lehman.
Hey, Mr. Chairman. I look forward to the discussion. I think we have, you know, when I made my opening comments a couple days ago, I made the comment, none of us expected to be dealing with the issues we're dealing with today when it came to COVID and immunity and things like that. So I think this is timely. I think we may have issues from a processing standpoint of getting this out. So I think we're going to have to probably hold. But I think what I hope comes out of this is, you know, when we look at our communities right now, every business is looking to us for help. And I think one of the things they're looking for is, I want to get back in business. I want to open my doors. I don't want to have to keep looking over my shoulder at who's on my doorstep, attempting to put me out of business because of some lawsuit. I think this is very, very important. It's very important that we move forward. I think from a process standpoint, as far as getting a model here and voting it, I guess my proposal may be, I think this is on or already moving through many general assemblies. I know it's a priority in Indiana. It's one of our top priorities. I think it's a bill you'll see move out the first week we're there. I think a lot of states are already doing that. So my question would be and maybe the process here would be, do we now take the time to say, well, we always have the tendency to come back and do things after we've seen how the impact it's had. Do we these states that push these things out the door the first week, do we take that? I mean, NCOIL is an excellent organization of gathering data and processing that. So do we gather that data up and say, what's kind of a best practices that we've seen? Because just you and I this morning, Chairman Rowland, we're talking about some different things on other issues, and you said, that's not a bad idea. I can maybe take that to Kentucky. I said, that's a great idea. I can take it to Indiana. I think maybe this can become a model that may not address the issue immediately, but I think we can get out there in March that now says this is what we have found to be the best practice. All of our states are dealing with this. All of them are going to do it a little bit different. Our organization, and we've always said, has been we build the foundation, you hang the drapes, but that foundation is going to have some structure to it. And I think giving it some time to look what other states put out there, we can create a really good foundational base on this. But I do think I think that we have to do something. So we have to continue to move forward on this. So I look forward to your leadership, Representative Rowland, on where we go with this, the engagement of the committee, the engagement of the states. This is one of those issues that I think kind of an all hands on deck from every state, giving your input is where we need to go. So with that, I look forward to the discussion. We've got some great people scheduled to give their thoughts. And with that, Mr. Chairman, I'll turn it back to you.
Thank you, Representative Lehman. And maybe after we can have some final thoughts on that after we hear the presentations from our speakers this morning. We do have 6 speakers signed up on this topic this morning. So I don't know if we could keep it 4 or 5 minutes, 6 minutes each. Might be able to stay on track of time this morning. So we'll go ahead and get started. The first speaker this morning will be Andrew Kirkner with NAMIC. Andrew.
Thank you, Mr. Chairman, members of the committee. I think if I had known I would be speaking so much on the last bill, I would have asked to go later, but hopefully you guys don't get tired of the commentary here. We want to thank you. NAMIC would like to thank the committee and NCOIL for the opportunity to speak to the NCOIL Coronavirus Limited Immunity Model Act. I think if we boil this bill down to its simplest form, it's accomplishing or attempting to accomplish something really important. Businesses and individuals alike need to be protected from frivolous lawsuits stemming from the global pandemic currently facing the country and the world. While the outbreak and more recent spikes in cases are troubling, I think for the first time in the last 9 months or so, there's some light at the end of the tunnel in terms of vaccine distribution and really the business world reopening in large part. Whether that takes place in the spring of next year or whether it's pushed more towards the fall, we do have a sort of perspective on when things will open back up. That said, as businesses open back up, as consumers return to stores, we think it's more important than ever to make sure that these businesses are not faced with rising litigation costs related to frivolous lawsuits. And one of the ways to do that, and as Mr. Lehman pointed out, that what states are already considering are limited immunity provisions across the country. We've seen bills in Ohio, Michigan, and a number of other states. And as the immediate past chairman pointed out, I was struggling before, Indiana, West Virginia, and other states are considering immunity provisions as we head into the spring sessions. So with all that said, we think the model currently before the committee is a really good start. We think it's a step in the right direction. And I think we have a few specific comments that I'll make to the committee. And then certainly I'm sure my colleagues will add on to that. So I think in terms of improvements or some suggested modifications to the bill, NAMIC and its membership believe a few things are important. I think from a threshold standpoint, one of the sort of hot topics in the immunity space right now is the idea of take-home liability. The bill specifically exempts it does specifically exempt workers' compensation law, any impact on workers' compensation law. In the take-home liability space, one of the concerns that our members have raised is that there will be individuals who contract coronavirus from individuals who bring it home from work, right? So the bill extends immunity to persons from liability for exposure, but it may not go far enough in extending that immunity to businesses and other persons for exposure to third parties, this so-called take-home liability. So we think that there's some improvement to be made there. We would certainly offer language in concert with NCOIL staff and our industry colleagues. We also think the bill contains a broad grant of immunity, except where there's intentional acts. Many states across the country would require a higher threshold of evidence when referencing an intentional act. So they would require, for example, a clear and convincing standard of evidence. We think, it may not be appropriate for NCOIL to lay out what each state's standard of evidence is for those intentional acts. But a drafter's note on that point is important because it would recognize that there are evidentiary differences as it relates to intentional acts. Finally, we think that there could be a broadening of the exposure language in the bill. At present, Section 3 provides immunity for the exposure to COVID-19. We think that language should be expanded to contemplate direct or indirect exposure. Again, that speaks to that part of that take-home liability I was referencing earlier. And so I'm not sure how productive it is to go point by point, Mr. Chairman, but globally speaking, I think this bill's a great start. One of the comments we received is that a bill that is concise and clean like this one has the best chance of success. We agree with that principle, and we think some small tweaks could really improve the bill and allow NCOIL to be a leader in the space. So I won't belabor the point. We probably will supplement our comments today with some written comments and suggested amendatory language, but we want to thank NCOIL for the hard work in this space and for being a leader.
Thank you, Andrew. Very good comments, and look forward to continue to work on and improve this model. Our next speaker this morning will be Wes Bissett, Government Affairs with the Independent Insurance Agents and Brokers of America. Wes, we really appreciate you dressing up for us this morning and looking forward to hearing from you.
No, happy to be with you, Chairman Rowland, and members of the committee. No, I don't always wear a tie for a Saturday morning breakfast, but for your committee, I'll make a special exception. So greetings from Baltimore. I appreciate having the chance to comment on this proposal. The Big I supports the efforts of the sponsors to take this issue on. The bill is a narrow and short one. It merely creates a higher culpability standard for a plaintiff bringing a coronavirus exposure lawsuit. We've seen numerous states adopt similar measures this year. I think as President Lehman made reference to, Congress is considering something along these lines, although in our view, the states are the appropriate venue for action like this. It's state law that typically addresses the assignment of liability. So we think it's very appropriate for state legislators to be considering this. Given the interest in this issue in many states, we think a model law is warranted. There may be legislators on the committee who feel like it's not appropriate or warranted for their particular states, and it may not be universally adopted, but there is certainly sufficient interest in this in many places to warrant model action. It would be an understatement to say that we live in stressful and traumatic and overwhelming times. We are in a global pandemic after all. But the pandemic's especially challenging when you're a business or an employer, and whether you run a nonprofit organization, a hospital, a school, a university, a small business, you're struggling today to make it through this storm. And you're not only worried about your personal situation and the long-term viability of your enterprise, you have the extra burden and pressure of knowing that you have employees and patrons that are relying on you. That's a special burden that the owners and operators of businesses and other organizations have, and they take it very seriously. Profit and nonprofit organizations are facing more challenges than we could cite as a result of the virus here. And what this model would do would be to eliminate one small and unnecessary source of concern. It's no secret that we live in a litigious society, and businesses are worried, as Andrew mentioned, about litigation as a result of the coronavirus. It can be an existential threat for businesses that are already on the brink. Many businesses are on the tipping point, and the threat of litigation can be that one thing that might force them to choose to close altogether. I mean, businesses are very exposed and vulnerable right now, and some might think that the safest course of action, the path of least resistance, the most reasonable thing to do in this situation would be to shut down altogether, but that would put patrons and employees in an even more vulnerable position than they are today. The threat of litigation in this environment's real. A business can take, frankly, just about every conceivable action that they might take to stop the spread of COVID, but COVID's everywhere. We face community spread, and it's not going to be a challenge for a plaintiff to bring an allegation against a business or nonprofit company that they'll then have to defend against. That claim may not be successful ultimately, but you do have to defend against it. In courts, without much direction, will be deciding what constitutes reasonable care in this uncertain environment. So the proposal, what it does is it encourages business in a manner that's consistent with the guidance and directives of state officials to remain open and to operate in a constructive and safe and responsible and good faith way. But it does give some degree of confidence to businesses and precludes the ability of courts to frankly engage in de facto COVID-related policymaking. The bill, though, is not limitless. It's not an absolute shield against accountability and liability. It doesn't shield bad or improper acts or allow bad actors to operate. It doesn't authorize or permit reckless or willful misconduct. And some might suggest that if you were to pass this, that we're going to see a parade of horribles, that there'll be bad behavior that will emerge, conscious bad behavior that will emerge as a result of a state passing this particular bill. We think such concerns are completely misplaced for several reasons. We don't think a business, once a bill like this is passed, is going to choose to become a bad actor, engage in bad faith action. It flies in the face of that business's own self-interest, its reputational concerns, the fact that it's trying to remain open safely to keep its employees employed and their patrons served. And perhaps most notably, the reason that's not a legitimate concern is that the bill itself would still permit plaintiffs to bring lawsuits in those kinds of situations. And we have not seen in states that have passed these types of measures the types of horrible behavior breakout that some have suggested might. The witness list for this morning's meeting, as I understand it, is insurance heavy, and that makes sense at an NCOIL meeting, but it does underrepresent the very significant and widespread support that proposals like this have from just about every segment of the economy. If I could have, over the last several minutes, just read the list of groups that are strongly supportive of this measure, but it's just about every segment of the economy, nonprofit, for-profit, public, and private sectors. So the bill has broad support from just about every conceivable business or employer that you can imagine. So as we begin, as Andrew alluded to begin to emerge from this crisis and get back on our feet in a collective sense and hopefully get our economy going again, businesses and employers are going to need all the support, encouragement, and certainty they can find. And this bill provides that in one limited and narrow context. So, Mr. Chairman, thank you again for putting this issue on the table. Thank you also to President Lehman. And before I wrap up, I just want to say I really commend you and NCOIL for a successful set of meetings over 4 days under what's been obviously very, very difficult circumstances. So thanks again.
Thank you, Wes, and we appreciate your comments. Next, we will hear from Lauren Pockman. She is Counsel and Director of Regulatory Affairs for the National Association of Professional Insurance Agents. Lauren?
Good morning. Representative Rowland, Senator Sawyer, members of the committee. My name is Lauren Packman. As was mentioned, I'm Counsel and Director of Regulatory Affairs for PIA National. We represent independent insurance agents in all 50 states, Puerto Rico, and Guam. Many of our agents themselves are small business owners, and many of them serve a clientele of small business owners. So we have a vested interest in making sure that small businesses are protected during this difficult economic time. Excuse me. As Wes mentioned, a small business could be easily bankrupted by a single lawsuit, even if it's a frivolous one. And many small businesses are just getting by, if that, in our current climate. They also need predictability. They are operating in accordance with, they're trying to operate in accordance with ever-changing federal, state, and local guidelines regarding COVID-19, openings, closings, curfews, time limitations on when they can be open, et cetera. The bill, as has been mentioned, reflects the movement around the country towards protecting small businesses with similar legislative efforts. And I think that this model sends a message to states that haven't acted yet that that this is a tool in their toolkit that they can use to protect the small businesses in their states. I wanted to note that as Wes mentioned, Section 3 in particular provides businesses that are in compliance with those ever-changing guidelines to be confident that they can open and they will not be the subject of frivolous lawsuits, or at a minimum, I mean, obviously, you can sue a ham sandwich, as everyone says. And so those businesses could still be subject to a frivolous lawsuit, but it will be much easier to dispense with that lawsuit in a more cost-effective manner with legislation like this on the books. The businesses that we're talking about, I think, are like Wes said, many of them are already on the brink, and they need all the predictability that they can get in the current economic climate. And this additional predictability provided by this bill will be the difference for some of them between solvency and collapse. I want to thank Representative Rowland and Representatives Rowland and Lehman for developing the model, and I'd be happy to work with NAMIC and NCOIL and IABA and anyone else on adding any essential provisions that that might be of value, including I think what the NAMIC representative mentioned regarding changing the evidentiary standard. I know there are also potential ways that statutes of limitations can be changed and things like that, and that could also be part of a similar drafting note. And I think that's all I have, unless there are any questions. Thank you so much for allowing me the time.
Thank you, Lauren. We appreciate those comments. Our next speaker this morning will be Professor David Vladeck, Professor of Law at Georgetown University. Professor, welcome, and thank you for participating this morning.
Well, thank you very much for having me. I'm going to be the fly in the ointment because I think you are embarking on a misadventure that will not help small business, will not help people who are harmed. And let's just start with some of the facts. This has been so far a fairly fact-free discussion, but so far we've had 16 million cases of COVID reported. We've had nearly 300,000 deaths. There's been almost no litigation. Almost no litigation. The Chamber of Commerce and NAM have been tracking this from the beginning. The cases that have been brought are cases that ought to be brought. People injured in packing houses because of their employer's failure to take necessary precautions. A couple of cases involving nursing homes, which were very slow to protect their, the people who were living there. That's about it. You want to look at how many small businesses have been sued over this? It's almost zero. So first of all, what is the basis for this legislation? Why do you think you need it? The tort system, in my view, has worked very well. Why have there been so few cases? Because causation would be extremely hard to prove in these matters, right? In order to sue somebody, you have to be able to show, and you need to plead that there is a reasonable connection between somebody's COVID and their injury. Well, guess what? Causation here is extraordinarily difficult to prove, and lawyers are not stupid. They're not going to bring a case that they don't have a substantial chance of winning. Why? Because they're fronting the money. So the first thing is, this is a, now you might ask, so, okay, so what does it matter if we have this legislation? Well, this legislation is incredibly over-inclusive, just the way the federal ones, resulting from exposure to an individual, right? The breadth of immunity here is extraordinarily large, undefined. And so, like the federal statute, which might have all sorts of unintended consequences, the breadth of this bill does not cure for that. Second, let's talk about moral hazard, right? You all know about insurance, right? This is classic moral hazard. Now, I understand why the insurance industry wants this bill. It's going to save them money if there are cases. But think about moral hazard. The question here is, what can we do to reopen our economy? What are we going to do to get people back to work? Is it really sensible to tell the public, you're on your own, unless somebody engages in an intentional tort, which is essentially a crime in every state, commits a criminal act, they are unprotected in the marketplace, right? Businesses that act responsibly are already protected from liability. Reasonableness is the cornerstone of our tort system, right? So we don't need legislation to protect the responsible. Immunizing companies from liability when they act unreasonably or irresponsibly would be utterly counterproductive and would impede the ability of states to reopen their economies. You tell people you're on your own when you go to the grocery store. There's no real requirement that your drugstore or whatever it is you go to is taking sensible precautions. That's not the right signal to send. The right signal to send is, if people act unreasonably, they'll pay for it, because that's the way the system has always worked. Look, there are two disciplines on our marketplace. There's regulation and there's tort law. There's so far been no effective regulation, and this is where the federal government has really failed terribly. There is no effective regulation, but there are guidelines, and if a company follows those guidelines, that company's got essentially an airtight regulatory compliance defense. That's the way it works in the law. If there's a regulation and you adhere to it, bad things happen, that's not your fault. That's the regulator's fault. But so we either need regulation through law, or we don't have a marketplace, right? Every time you go to the grocery store and buy a pound of flour, you know you're getting a pound because the initial regulatory system had to do with weight and measures. Now we have public health measures. And so, the model bill, there are also all sorts of problems that you haven't even started to think about. What about What about cases that have arisen prior to the passage of the model bill? There'd be a huge constitutional issue if you tried to wipe away those claims, right? Do you have the constitutional power to wipe away a property interest someone had in a legal claim retrospectively? So I know time is short. A lot of the discussion so far has been on frivolous cases. So Mr. Kirshner's argument was, we need this to curb frivolous cases. The courts know how to do that. You file a frivolous case as a lawyer, you pay a price. This has nothing to do with frivolous lawsuits. Another justification is there is a reasonable measure and bounds here because it only involves essentially intentional torts or gross negligence. Well, intentional torts are crimes in every state, as is what is called gross negligence. So what you're really talking about is the only cases that can move forward on this bill is somebody goes out and intentionally tries to harm someone or engages in an act that is so reckless it meets a gross negligence standard. So think about somebody firing a gun towards a crowd or someone driving quickly through a crowded pedestrian area. That's what gross negligence is. If you have any doubts about it, I testified before the Senate Judiciary Committee. Look at the testimony, it's on their website. I talk about state law throughout the country. Take-home liability. Let's talk about take-home liability. Take-home liability exists in very narrow cases. The only cases so far that have been brought on, quote, take-home liability are in the meatpacking industry. Up in Green Bay, in Iowa, workers got sick. There were huge outbreaks in these facilities. They went home and their spouse and their children got sick. Should they bear the liability for that? That's what that bill would say. Tough noogies for them, even though this was not through any fault of their own. So look, if you want to just protect criminals, that's what this bill does. It does not protect. If you go look at it, right, what you're talking about is gross negligence or willful or reckless conduct. Go look at the law of your states. You will find that all of those things overlap with the criminal law. The liability issue here is much more important in terms of signaling than it is in the actual caseload that's going to follow. We've been with this for almost a year. There have been almost no cases of the kind that you guys say you're fearful of. But law signals a lot, and a law that basically says you're on your own in this marketplace. If someone hurts you but didn't do it intentionally or willfully, tough noogies, that doesn't send the right signal. That is the sort of the perfect illustration of moral hazard. And I would urge you to take a step back, actually look at the data, which we haven't discussed at all. Where are the cases? And then let's move forward. Thank you so much.
Thank you, Professor. We do appreciate your comments this morning. We do seem to be staying on pretty well on time. We have two more speakers this morning, and then we'll get into some questions and comments. Our next speaker this morning is Rebecca Dixon, Executive Director, National Employment Law Project. Rebecca, may proceed.
Good morning. I'm here to bring you the worker perspective on this issue. Worker health really is public health, and workers' rights to a healthy and safe workplace must come before profits. We simply aren't able to reopen businesses and public institutions if workers and consumers aren't safe and don't have confidence in their safety. Granting employers the immunity that some have long sought would create disincentives for even law-abiding employers to protect their workers. producing a race to the bottom for workplace standards, and would cause a health and safety disaster with new hotspots across sectors and spread across communities. I want to leave you with 3 points. Point 1, when employers across the country fail to adequately protect their workers, they contribute to the spread of COVID-19 into communities. And due to historic inequities, this impact is uneven. Where workers are actually located in the labor market determines who is now able to work safely from home, who is out of work, and who is reporting to work and taking a daily risk. The concentration of women and people of color in low-paying occupations ensures that they are the workers who are disproportionately in jobs on the front lines of COVID-19. And they often work in industries that don't have health benefits or sick leave and have few worksite protections already. I encourage you to consider the impact of your policymaking. What does the data tell us about this recommendation, and who is advantaged most by it and who is disadvantaged most by it? Who benefits? Who is burdened? And history really shows us that it's important to consider unequal impacts. For example, without ever considering race or mentioning race, maybe they considered it, but without ever mentioning race in the historical record, the way people were stratified into the labor market enabled the exclusion of millions of workers from the New Deal programs, including 90% of Black women, because they were concentrated in agricultural and domestic work. There are many examples of how employers have been slow to follow the basic CDC recommendations. And in the interest of time, I'll just talk about one. As the coronavirus ripped through a pork processing plant in Waterloo, Iowa in April, Tyson's food supervisors not only kept the facility open, but they also placed bets on how many workers would catch the virus. One plant manager allegedly organized a cash buy-in winner-take-all betting pool for supervisors and managers to wager on how many employees would get sick and test positive for COVID-19. Let me be clear, workers are getting sick and dying, and these are tragedies that are preventable. Second point, the rule of law versus the honor system. Right now, employers are operating on the honor system unless their state has issued enforceable guidance. The CDC guidelines are advisory and not enforceable, and OSHA has failed to protect the health and safety of workers during this pandemic. Workers are already really challenged to enforce any of their rights and get access to the courts because of things like forced arbitration and collective action waivers that they sign when they take their jobs. This is also true for health and safety. OSHA has utterly failed to protect workers. It's voluntary, standard is voluntary, not enforceable, and it's not enforcing any of the CDC voluntary guidance either. Unlike other statutes, workers have no private right of action to sue if an employer is violating OSHA, including when their employer retaliates against them for raising a health and safety concern. They only have an administrative remedy to file a complaint and request an OSHA inspection. Workers have filed thousands of complaints, but OSHA has conducted few, if any, on-site inspections and issued no citations protecting workers from COVID-19 exposure at work. Workers who speak up are facing retaliation. According to a recent survey, Black workers twice as likely to face retaliation. What about workers' comp? For workers injured on the job, workers' comp is this no-fault coverage, but you give up the right to sue for negligence. It's not really clear how much coverage workers' comp is going to have for COVID, since workers' comp generally does not cover routine community spread illnesses like cold or flu. And my last point, immunity is really a solution in search of a problem. There is simply no flood of litigation. According to various COVID-19 lawsuit trackers, somewhere between 116 and 234 lawsuits over issues like lack of personal protective equipment, exposure, or infections at work, or death have been filed to date. That's about 2 or 4 lawsuits per state. That's a trickle and not a flood. And finally, it's important to know that while supporters of immunity may claim that they are primarily focused on preventing workers and consumers who get sick from suing them, we need to be clear that the trade associations who lobby for employers, including the Chamber of Commerce, the Restaurant Association of America, National Association of Manufacturers, and the National Federation of Independent Business, to name a few, are pushing for legal immunity from a wide range of core worker protections. The immunity sought by these associations and employer-side attorneys would extend to violations of a worker's right to minimum wage, overtime, right to not work when you're off the clock protections, and disability discrimination, including and also the right to paid sick leave and paid sick time under the Families First Coronavirus Response Act. Throughout history, in moments like these, where we face both the pandemic and a public health crisis, our challenges are also opportunities. How employers and policymakers respond in this moment could improve work in the United States for the long term or make the existing problems worse. Thanks.
Thank you. And our final presenter this morning is Frank O'Brien, Vice President of State Government Relations for the American Property Casualty Insurance Association. Frank, thank you for being with us.
Thank you, Mr. Chairman, and thank you to the members of the committee. Let me begin by saying kudos to Professor Vladek for working the phrase tough noogies into his presentation. And I would look forward to taking any tort class that has the concept of tough noogies as part of its core curriculum. The professor and opponents of this particular proposal would suggest that what it basically says to workers is tough noogies, you're out of luck because of these particular provisions. I would suggest that the professor's position and others would equally say to business communities, to Main Street, businesses in our communities, to Main Street America, tough noogies to you, you followed the rules and now there's a potential that you could face some additional liability coming your way. In that regard, this is the quintessential public policy question, and state legislators and organizations like NCOIL are well positioned to determine whose noogies are going to be tougher. This particular type of issue is a classic public policy question. And it is something that a number of your colleagues in several states have wrestled with. As Representative Lehman noted, it is also something that more states are going to wrestle with coming on down the pike. One of the points that opponents of this type of proposal would make, have made, and did make this morning is that there are not a lot of lawsuits out there at the present time. Taking them at their word, which I do, and assuming that their statistics are correct, which I have no reason to suspect that they are not. That's today. What about tomorrow? What about next week? What about what happens when Main Street America begins to reopen, when we begin to move into an area where we're in, if I could borrow a phrase from legislating, when we're in regular order, when the doors of the courthouses are open, where trials are being scheduled, things like that. Plaintiffs' lawyers and their supporters will say, see, as they have here today, there are no cases. But with courts shuttered and the statute of limitations on their side, folks are not under any immediate need to file the cases. There may be practical issues. There may be statute of limitations, prejudgment interest issues and concerns. There may be tactical and strategic questions. Individual lawyers in their offices may be weighing whether or not to take a case, file a case. There are lots of reasons right now where there may not be an immediate tsunami of cases, but there could. For Main Street America, who has been worried about their survival, the potential for litigation coming on down the road is another concern. Imagine yourself, you've done everything that you could possibly think of, and you've followed the rules. And the rules in your state, the rules in your community, and all of a sudden you have a suit filed against you. Well, it is true that as we go through the litigation process, you may do well on that suit from your perspective. You may be able to defeat it. But sometimes the mere filing of litigation is as damaging as going through the litigation process itself. There's a cost perspective, there's an emotional perspective, etc. That is not to say that there will be instances where litigation is warranted. There may very well be. And in situations, and I would note in this bill that it is crafted in such a way that if a defendant acted intentionally, willfully, or recklessly, a claimant could pursue damages. It's not a complete bar. And it is going to be up to state legislatures across the country to determine what the bar should be. If there are situations where a business has acted recklessly, has put their workers, customers, the general public in danger, has not followed the rules, has done so intentionally or recklessly, then they should suffer the consequences. And we think that that is something that should play out as issues such as this are debated within the state legislatures. Finally, I would note that several states around the country have crafted legislation on this. It is a developing area. It is an area that is ripe for NCOIL to consider. It is directly in NCOIL's wheelhouse, and we would support NCOIL continuing to look at, discuss, debate, consider this very important public policy issue. With that, Mr. Chairman, I'd be happy to answer any questions.
Thank you, Frank. We always appreciate you being with us and your comments. We do have some questions. The first one is Representative McCoy from Kentucky. He's the majority whip, and I believe actually working on some of this legislation for us that we may consider it the first week in January. Representative McCoy.
Thank you, Chairman Rowland. Can you guys hear me okay?
Yes, we can.
Okay, great. So just quickly, for the background for folks that don't know me, I'm kind of the purple unicorn. I'm a Republican and currently plaintiff's lawyer. Excuse me, but I have been a defense lawyer for a lot of my career and also now on the other side. And we've got a real balancing to do here. You know, I have traveled around our state in Kentucky as a member of leadership and hosted.
Chad, we're losing you, Chad. I think you're coming in and out. You may be moving around a little bit.
Any better now?
A little better now, yes.
Okay. So, you know, I've had the opportunity to go hear from businesses around our state, and this is a very real fear. But as the professor pointed out, the data's just not there right now. And in this organization, what we've really got to do is this important balancing. You know, frivolous lawsuits need to be stopped immediately. People need to be punished for frivolous lawsuits. But at the same time, we can't allow bad actors to get away. So what's very important, I think, for the business community is that we give them something that's real, but it's also constitutional. And one of the fears we have in Kentucky with the Model Act, and Bart's right, we're working on a slightly different one. We want to make sure that this doesn't have retroactivity because that'll get kicked out. We've got to keep in mind there's a vaccine coming. We're looking at a short window of cases here. And I would like to just maybe throw out for people to chew on something that we've done in Kentucky in a similar area, and that's the medical malpractice area, is the concept of a certificate of merit, a requirement that as a part of filing a lawsuit, the plaintiff and the plaintiff's attorney have to file a certificate saying they already have an expert that will testify not only as to a breach of the standard, but also to causation. And again, causation is probably the real hiccup in these cases. It's going to be almost impossible to prove. But with a certificate of merit, you would immediately cut away any of the frivolous lawsuits. And what you would be left with is ones where there is a legitimate, though arguable, doesn't mean you're going to win, doesn't mean you're going to lose, but it's arguable now, some sort of breach of standard and causation. So just throw that out. We've got to signal to the business community that we are behind them. We need this economy to open up, but at the same time, we've got to keep that balance and not throw the baby out with the bath, so to speak.
Thank you, Representative McCoy. Excellent comments. We have a question or comments from Representative Kaiser.
Thank you, Mr. Chairman. I have a question for Professor Vladeck, if I could. Professor Vladeck, I'm from North Dakota. We're a super red state. We have a lot of folks who are strong supporters of the president, and not only politically supportive, but supportive behaviorally, and frequently don't choose as a source of freedom to not wear masks, social distance, etc. We have a lot of business owners like that. So my question, and I apologize, I'm not an attorney. I don't understand state tort law, but it seems to me that if this were passed in our state, it would eliminate any requirement to follow science for any employer in terms of social distancing, masks, tracing, because there just isn't a requirement. We exempt them from that because it's not part of this. There is no requirement to follow science or to use reasonably objective responses. And I'm just curious from a legal standpoint, would that be true?
You know, that's a really good question. And I don't know whether I have a really good answer for it because community standards matter in tort law. And if the community standard is that you don't need to wear a mask, a jury of someone's peers is unlikely to ding a small business owner for not requiring masks. My understanding is your governor doesn't allow masking requirements in the state. And if that's true, and I may be misinformed about that, that would complicate tremendously any effort to bring a tort case. I haven't looked, state by state in a while, but when I last looked, there was no tort case involving COVID in North Dakota, and maybe that's the reason why. So I'm sorry I can't give you a more robust answer, but community standards matter. Let me just take 1 minute, if I may, Mr. Chairman, to respond to Mr. O'Brien's point about timing. If you want whatever cases to be filed now rather than later, just go to the legislature with this kind of bill, because retroactivity is not on the table. Whatever you do is prospective only. And so if you want people to file cases, move this bill through a state legislature and lawyers will then file whatever cases there are. But, the threat of legislation has been looming ever since Senator McConnell, drew a line in the sand about this. And so I think your speculation that people may be waiting to bring these cases probably is unfounded, largely because of the risk that if you wait too long and there's a liability bill, then you may be stuck. But none of this legislation can be retroactive. Thank you, Mr. Chairman.
Thank you. We are coming up on the 10:30 mark, and we have 2 more topics after this. So I will recognize Senator Hackett for to be our final question or comment this morning. Senator Hackett.
Thank you, Sir Chairman. I know you can hear me. In the question we all have said, and Ohio's has a really good law, and you laugh, it is a retroactive, but the question always came up, and among us, we said, how can we ask business to be open and stay open if we don't provide protection? One of the things I want to ask the professor is, Ohio's different than the Dakotas. Ohio's a state where many times we're a red state, but the cities are blue. And so when you look at the situation is, our governor and our legislature a lot of times operate on, just don't get along. And the governor, to work with us better, is not issuing laws and mandates. He's really issuing guidelines. So the scenario is, how do you operate in the state? And the difference between the rural areas and the city areas, you're right, communities do imply? Well, when we first had the pandemic, it was the city areas that were getting hammered and the rural areas were not. So the question I have to you is, how does this operate in the state? And by the way, I got a bunch of calls from people who said, hey, look, you can't take the right of suit and there's no way this business should open. And so, but the business had the right to open and to deal with the issue of the rights of the individual. So my question is, how do you operate in a state where you have really differences of opinion politically and area-wise?
So this is the same problem that North Dakota has. I mean, one flippant answer, but true, is the less people are wearing masks and doing social distancing, the more difficult it is ever going to be to prove causation. And, one of the reasons why there have been so few cases filed is because the causation problem for the plaintiff is almost insuperable. And so in North Dakota, where people are not wearing masks, or in the rural areas in Ohio where people are not wearing masks, proving causation would be essentially impossible. Because causation is the foundation of tort law. You can't sue someone unless you can show, and the plaintiff bears the burden on this, can show that it was the defendant who actually caused whatever injury you're complaining of. And so that's a practical answer. It's not a legal answer. But
So
I'm sorry.
Just to follow up, then why is our BWC paying a high percentage of claims that are turned in from essential workers? I agree, they're essential workers. Why are they paying them under BWC? Are they doing it just out of their good heart, or why are they paying such a high percentage of claims as being at business, that the cause came at their business?
I don't know, but I'm not aware of, I don't know what you consider a high claims rate. A lot of the essential workers in the United States were exposed because they didn't have adequate PPE. There was no social distancing. You see the outbreaks in prisons, in packing plants, in nursing homes. That's where the outbreaks are, and that's where the cases are so far. So I don't know about, the situation you're discussing, but that's where you've seen the cases. And Professor Scales from Rutgers says he can answer that question. So let me simply defer to him.
Thanks. Let me be very brief. Of course, the causation and fault standards applicable in a workers' compensation context are completely different. The whole point of workers' compensation was to reduce the burden on injured workers in establishing fault. Professor Vladeck has wisely focused on causation as a huge issue here, and that often intertwines with the question of fault. So if an employee catches COVID and files a claim, I personally think that there are quite interesting questions about whether causation can be established there. California went pretty far in seeming to articulate I think an irrebuttable presumption of causation. I think that's probably a mistake. But under almost any workers' comp plan, the burden is simply going to be lesser for such an employee compared with a hypothetical tort claimant who, as Professor Vladeck points out, would face substantial hurdles in bringing a claim.
Mr. Chairman, if you wouldn't mind, if I could jump in briefly, I think part of the discussion here is regarding workers' compensation claims. The model before the committee specifically exempts the workers' compensation statute, and I would love to sort of respond to Senator Hackett's comments. Ohio is one of the states that I cover and helped work on that immunity bill. I did promise that I would stop engaging with law professors after I barely got out and passed the bar, but here I go again, and on a Saturday morning, no less. I wanted to respond. Professor Vladeck said that this was a largely fact-free discussion, and then proceeded to make the statement that all of the cases that have been filed so far ought to have been filed. It's very difficult to operate inside of a framework where every case that's filed is valid. It would be an interesting conversation that we don't have time for today to do a deep dive on the number of tort cases filed that actually go to a jury or a verdict from the bench. In fact, most of these cases settle. The fact that there isn't some massive amount of cases in the pipeline right now is the result of a number of things, not the least of which the fact that courts have been closed, and that there is an often two-year statute of limitations on many of these claims, and that statute of limitations obviously varies across the country. The point here is that just because the cases don't exist today in the volume that would, in the professor's mind, lend credence to a bill like this, doesn't mean they're not coming. As insurers, we see frivolous lawsuits every day. I think it's certainly reasonable to expect that those lawsuits, whether causation is an issue or it's not, will occur here. And the bottom line is that litigation drives up the cost of insurance. And really, my comments at the outset of this discussion were, this is a time where small businesses and large businesses alike can least afford it. The bill does not create a criminal acts standard. In fact, it very specifically mentions a reckless misconduct standard, which would not be criminal act. So, Mr. Chairman, I appreciate the leeway and thank you for involving us in the discussion this morning.
All right, thank you all. It's certainly been a healthy discussion, and appreciate everyone's participation. I'm looking forward to reading the words "tough noogies" in the minutes later this summer. Look forward to approving those in March. We're coming up on a little past 10:30 now, so we do need to move forward with the next two topics this morning. Topic number 4 is the introduction of amendments to NCOIL Post-Assessment Property and Liability Insurance Guarantee Association Model Act. That is being sponsored by Assemblyman Ken Cooley. Assemblyman, when you are ready.
Very good, Mr. Chair. Delighted to jump in on this one, and I will try to be brisk in view of the time. This model, of course, was readopted at the September meeting, but at the time, I sort of felt there were some loose ends that we would want to address. Of course, within the realm of insurance, where people are buying a promise of future performance, the first line of defense for all customers is actually the rating system, meaning how we set rates for insurance. That's what protects the public to have adequate funds to pay future claims. The second line of defense, very important, however, is guarantee funds. So if somehow an insurance company runs aground that there is an alternative to just the customer bearing that loss, we distribute that loss through the guarantee system. That raises the issue on these insurance division acts to make sure that in transferring a book of business, that there is not any unintended consequence with respect to when the business gets transferred, the people remain fully protected on the guarantee funds. And to ensure that, it's actually very important to listen to what the guarantee funds have to say about their technical rules of coverage and how it gets funded. And that brings us to these amendments. They're in the binder. The first proposed amendments on page 244, and it's would adjust the model we passed in September to ensure that insurance business that have been restructured remains appropriately covered in the guarantee fund. The concern would be that guarantee fund laws may not protect claimants on policies that are transferred pursuant to this type of transaction. And the language that we would be adding today would reflect the policy position that claims that would have been covered before the transaction would remain covered after, but it would not expand and create new exposures to the guarantee fund beyond that expectancy in the original transaction. The second amendment's on page 248. Guaranteed funds all have assessment provisions, and there is generally a cap on those provisions. This amendment will clarify that the assessments to Insurance Guarantee Association members will fund the claims and the operation of guarantee funds, so it's in an always ready posture. This permits them to plan in advance, but should be noted that the administrative expense would not exceed the 2% threshold. So I just feel really these are highly technical amendments to reconcile the model that we have previously adopted, which is a good model, to just make sure that in all cases, the guarantee funds operate without any unintended consequences, would actually be a shocking occurrence that suddenly someone who should have been covered is told they are not covered. So that's, I propose these and look forward to working on these amendments with the committee, Mr. Chair. Return the conversation to you.
Thank you, Assemblyman. I do see that we have a representative from the National Conference of Insurance Guarantee Funds on Zoom that has some comments to make.
Thank you, Mr. Chair. I'm Barbara Cox. I am with Barbara F. Cox, LLC. I am representing today the National Conference of Insurance Guarantee Funds. And I have to say, Representative Cooley did an excellent job explaining the provisions. The National Conference of Insurance Guarantee Funds, as Daniel Llewellyn stated yesterday, takes no position for or against restructuring transactions. We do believe that if there was coverage before the transaction, there should be coverage after the transaction. Conversely, as Representative Cooley pointed out, we believe that there should not be guarantee fund coverage created by the transaction. And the First Amendment clarifies that in our model law. We have some concerns right now that in many, if not most states, under current law, there's a real question about whether these transferred claims would be covered by the guarantee associations. Hence, we've developed an amendment. It's been through our legal committee, well vetted by our board, and we would recommend that the NCOIL organization adopt this amendment and include it in their model Property Casualty Guarantee Fund Act. The second amendment, as Representative Cooley pointed out, concerns special assessments to essentially keep the doors open on the guarantee funds. We had a year-long study that included our board members, guarantee fund managers, several industry representatives. And the concern was that under current practice, funding of the guarantee funds is very much tied to claims volume. And what that means is a fund could be sitting with maybe in a small state, maybe 10 claims and not really have the wherewithal to assess the industry to keep the doors open. Conversely, they can make a claim against the estate. Sometimes that can be objectionable because the claim cost per claim would be so high if that were done. This is an optional provision. States may have many other tools, either in their plan of operation, their law, or in their practice to make sure that their doors remain open. The other question is, why do we have to keep those doors open? I've been involved with the Guarantee Association system for over 25 years. I can tell you that a fund can go from 3 claims to 3,000, maybe 30,000 overnight. We do encourage pre-planning for liquidations. It doesn't always happen that way. Hence, we want to make sure that to the largest extent possible, the claimants against a guarantee fund get pretty seamless coverage. That's not always totally possible, but to the greatest extent possible, their coverages are not disrupted by the liquidation of the insurance company. That's what we're all about. I'd be happy to answer any questions anyone might have.
Thank you. Thank you for those comments. Thank you, Assemblyman Cooley, for introducing the amendments. We'll keep working on this topic and I guess probably hear about it again at our meeting in March. We'll go ahead and move on now to our last topic this morning, which is update on the no pay, no play laws. Our first speaker this morning is Professor Adam Scales, Rutgers Law School. Professor.
Thank you very much. Saving the best for last. Certainly appreciate that. This is a nice break for me. Spent much of the past few months giving interviews and hosting webinars devoted to COVID-19 liability and insurance topics. So thank you for this break. Although I wish I'd known about the preceding topic sooner, although I must say I would not have been able to improve upon Professor Vladek's presentation, which I commend to your considered attention. Thanks also to Will for inviting me. When he mentioned this topic to my colleague, Jay Feynman here at Rutgers, I teach at Rutgers Law School, along with Jay, I'm a co-director of the Rutgers Center for Risk and Responsibility. When Will mentioned this to Jay, neither Jay nor I had heard of it. And it's rather embarrassing. I mean, I've been teaching insurance law for 23 years. Fortunately, Jay's been teaching for about 40, so there's enough embarrassment to go around. And I'll come back to a lesson that we might find in that. For those, if there's anyone here who is equally uninitiated, no pay, no play laws substantially restrict or eliminate the right of auto accident injury victims to sue for negligence where the injured person was uninsured. Now, there are several variations that you can find sprinkled across the dozen states that have enacted this legislation either through citizen initiative or usually through legislation. Sometimes, very occasionally, the disability is only up to a threshold amount. So that if your claim falls below that amount, you can't sue, but if it goes above that amount, you could sue. A common restriction is that the disability applies to non-economic harms, pain and suffering, emotional distress. Not infrequently, the rule is written so that there's no cause of action at all for this injured but uninsured person. The wording of at least some of the legislation is at least open to the interpretation that disability might extend to non-motorist defendants as well, but I need to study that further. There is a frequent carve-out in most of these statutes. If the defendant motorist is guilty of a DUI or committing a felony or something similar, then the disability on the injured but uninsured motorist suing does not apply. Okay, as I said, these have been enacted by about a dozen states since 1996, and there are several justifications that have been offered for these laws, which you can see reflected in the resolution. Some of these are somewhat interlocking, though they also contain some seeds of contradiction. One idea is that this will reduce premiums. Another is that it will reduce fraud. It is hoped that such laws will reduce uninsured driving by making uninsured driving relatively more expensive for individuals. And then finally, there is the overarching appeal to fairness. Now, there is some limited evidence for the effectiveness of these measures. We might hear some more about that with the next speaker. Rand and others use models to estimate the impacts. And the last round that I found dates back to around the 2012 timeframe. And the estimates pointed to approximately about 3% reduction in premium costs per insured driver, which I think was about $5 a month at the time in Texas. Now, I think that might be a bit optimistic, but lower payouts should indeed show up as lower premiums at some point. So let's assume that this projection is accurate. Now, 3% isn't zero. And I suppose if one had the opportunity to select multiple low value interventions, they might indeed add up to real money in a family budget. That said, it is important to keep this relatively modest benefit in mind when assessing these proposals. On the issue of reducing uninsured driving, that's extremely unlikely that no pay, no play has an effect on that. It doesn't meaningfully change the incentives for the types of people who are likely to be currently uninsured. And if the average non-consumer, the uninsured driver, is as ignorant as two professors of insurance law, the incentive potential might be muted even further. The reduced fraud rationale is also a bit tenuous. Now, the effectiveness of the strategy turns on the sensitivity of fraudulent and only fraudulent claiming to no pay, no play laws. But this is an extraordinarily blunt instrument, one that punishes fraudster and legitimate victim alike. Now, fraud in low value PIP claims is a real problem for the insurance industry. But basically, this is a concession of failure. Unable to detect fraud when it counts, insurers ask to wipe out legitimate claims that share exactly one indicium of potential fraud, the lack of insurance. This brings us to the fairness rationale. Now, it turns out that there is a long history of interest in shutting the courthouse door to morally questionable claimants and their legitimate claims. This has been known as the outlaw doctrine. And at different times in our history, the law has disabled those who were injured while committing crimes or other bad acts, like driving on a Sunday, from suing in tort. Now, by definition, this eliminates claims without regard to their validity. For most of the past century, such defenses were rejected by American law. By the 1950s, two leading scholars of torts could dispose of the outlaw doctrine as, quote, a barbarous relic of the worst there was in Puritanism. Well, the more things change, the more they stay the same. In some other work I've done, I've had occasion to observe that every age fits the practices of the past into the felt necessities of the present. Only the rationales change, as each successive age discards earlier, old-fashioned reasoning in favor of enlightened, modern reasoning that, rather amazingly, ends up sounding a lot like the olden days. This is no different. With that in mind, I want to talk about the fairness aspects of this legislation. In my view, it inappropriately conflates the source of the right to injury compensation with the likely source of the funding for that compensation. Simply put, the moral and legal basis of an injury victim's claim stems simply from the commission of a wrong by the defendant against the plaintiff. That's it. We don't ask whether either party is rich or poor. We don't make inquiries as to the religious habits. We have even discarded, by overwhelming consensus across the states, the concept that directly relevant negligent behavior by a plaintiff should entirely eliminate his right to recovery. The conflation at work here is to elevate plaintiffs' non-compliance with mandatory insurance requirements beyond any considerations of defendant or plaintiff fault. This appeal to fairness is easily seen in the catchy title, No Pay, No Play. But the point of rights, including those secured by federal and state constitutions and the common law, is that you don't have to pay to enjoy them. That's why they're called rights. I want to point out that the carve-outs, while politically understandable, contribute to the conceptual confusion here. Drunk driving is bad, but it's difficult to understand why an uninsured claimant with a relatively modest injury claim against a drunk driver is free to sue, while someone with a catastrophic injury occasioned by a sober driver is cast out of the law's protection. In a weird way, these kind of carve-outs recreate for defendants the all or nothing rule that the law long ago discarded for plaintiffs. Moreover, this carve-out has literally nothing to do with the alleged rationale for no pay, no play laws. The frequent restriction of the disability to non-economic harm is also disingenuous. If someone has failed to play by contributing to the insurance system, why should his right to recover turn on the particular pathway his injuries take? Two claimants with identical injuries or very similar accidents might be differently situated as to the ratio of economic to non-economic loss. Okay, so nothing's perfect in public policy. I get that. But the policy of treating non-economic injuries as second-tier optional harms susceptible to waiver by non-payment, it is one congenial to liability insurers, which apparently was enough in 12 states, but I don't think it's really persuasive to anyone else. Let me close by trying to say something nice about no pay, no play. Now, we don't have true fault insurance in this country. Low injury thresholds mean that in virtually any case with meaningful injury, a plaintiff can resort to the tort system. In theory, one might reimagine a no-fault system that could truly be thought of as creating a broadly applicable threshold on injury suits as a matter of protection for citizen motorists. We have homestead exemptions and other personal exemptions across tort law. And with some work, I could see fitting an auto no-fault system into the same framework. In this framework, motorists would have a legal, not merely practical immunity from suit below a certain threshold in exchange for participation in the system. Some of the no play laws seem to work kind of like this. Louisiana actually comes to mind as a threshold. And I would argue that this limited disability, we'll call it threshold disability, might be the basis of a defensible and conceptually coherent public policy. Unfortunately, that's not what we have at present. I recommend not adopting the proposed resolution reaffirming no pay, no play laws at this time. And I'm happy to answer any questions. Thank you.
Thank you, Professor. Our last presenter this morning, and we are already out of time, but we'll still proceed on, is Andrew Kirkner with NAMIC. Andrew?
Thank you, Mr. Chairman. I will truncate my comments in the spirit of that time constraint. I want to thank you and the committee for addressing this important topic, which really speaks to the world of affordability of auto insurance and public policy. I appreciated Professor Scales' presentation, although I certainly would dispute a few points he made in it. Without getting too bogged down in the details of this bill, NAMIC really believes there's a more appropriate way to refer to these laws. I think the laws that have historically been described as no pay, no play, really put the wrong context on this discussion. A more appropriate title and maybe something like Missouri, a Missouri legislation that was titled Fairness for Responsible Drivers. Now, Professor Scales just spoke to the fairness rationale, and I'll address that in just a moment. But this may seem like a semantic difference, but it's not, because what we're talking about at the end of the day is insurance. And insurance is a system of pooled and shared risk in which individuals participate. The sort of complicating factor to that system is that, at least in this country, the vast majority of states, with just one exception, have mandated participation in that system. So in 2014, NCOIL took a look at this issue and adopted a resolution. That resolution did two things. First, it limited the ability of illegally uninsured drivers or owners to collect non-economic damages. And second, it did maintain rights for those same illegally uninsured drivers to recover even those non-economic damages in a very limited set of circumstances, including where that person was a pedestrian, where that person was an occupant in a car, or where they were injured by an at-fault drunk driver or a fleeing felon. I think that's an important distinction that I would bring to the committee's attention. That was not, unless I miss it, I don't think Professor Scales touched on that. What this resolution did, and really what NAMIC supports, is legislation that would prohibit illegally uninsured drivers from collecting the benefits of a system in which they do not participate. This bill does not bar the illegally uninsured driver from collecting non-economic damages. I'm not sure there is, I would actually draw a distinction between economic damages and non-economic damages. I don't want anyone to leave this discussion with the idea that these fairness for responsible drivers laws in the states prohibit collection of economic damages or the recovery of economic damages. In fact, by and large, the bills are limited to those non-economic damages that were referred to both by the professor and here. So I think that's an important distinction. NAMIC would support NCOIL returning to continuing a discussion around these laws. It would support model legislation that closely tracks with that 2014 resolution, which would in fact bar recovery of non-economic damages while maintaining the rights of those same uninsured drivers to collect in non-economic damages in certain capacities. Lastly, Mr. Chairman, I did want to hit on a substantive point, which I think was perhaps glossed over in the earlier presentation. And that is, what's the point of a responsible for outside of fairness? What's the point of these laws? One of the rationales is an attempt to reduce the number of uninsured persons in a state. I think this committee and NCOIL more generally are well aware of the impact of uninsured drivers on the overall insurance climate. A 2012 study by the IRC to the Nevada legislature indicated that there could be, and likely was, some tie between these laws and a decreased number of uninsured drivers in a given state. I think it's very fair to say, from an intellectual honesty perspective, that study could be updated and certainly could use some additional development, which is something that NAMIC would support in this space. That is outside of the fairness rationale, but I would return in closing to that point. Individuals who do not participate in the system should not be able to inherit the benefits of that same system. This is a fairness perspective, and we would encourage NCOIL to continue this discussion and perhaps work towards the development of model legislation in this space. Appreciate the time, and I'm happy to try and answer any questions the committee might have.
Thank you, Andrew. Do we have any legislators either on Zoom or in person who have comments or questions on this topic? We can take one real quick if anybody has one. If not, thank you. That does conclude our topics for consideration this morning. Is there any other business that needs to come before the committee? Seeing none, I would move for a motion to adjourn.
I so move.
And a second.
Second.
And we are adjourned.
I'm going to call the meeting to order, and we're going to do ask those who are on Zoom, legislators who are on Zoom, to identify themselves.
Senator Ken Cooley, California.
Neil Breslin from the great state of New York.
Jim Seward, also from New York.
Kevin Cahill, still from New York.
George
Matt
Scott,
Lester from
North
Far Off,
Dakota.
Connecticut.
Edmund Jordan, Louisiana.
Tim Gooch, Kentucky.
Peggy Mayfield, Indiana.
Bob Hackett, Ohio.
Oh, all I saw was a ceiling fan. That was, as you said, Hackett. So
Yeah.
welcome. I think, is that everybody on Zoom? I think that's everybody from Zoom. Let's go around the room. Legislators who are in the room. We'll start over here with Representative Carbaugh.
Martin Carbaugh from Indiana. Mike Gaskell from Indiana.
Mike. Travis Holdman, Indiana. Paul Etke, Minnesota.
Sean Vita, North Dakota.
And I'm Matt Lehman. It is, I just realized the Midwest is very well represented here. So you can tell who wanted to get out of their cold states. I'm going to ask for a motion to waive the quorum. Second. All in favor? Vote aye.
Aye.
Opposed? I need a motion to adopt our minutes from our meeting in the 26th of September. Is there a motion?
So moved.
Second. All in favor, say aye.
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 Okay, before we get to our traditional business of this committee, I'm going to take a moment to recognize retiring NCOIL past president, New York Senator Jim Seward. The very first year I came to NCOIL was the year that Jim Seward was president of NCOIL. I think I was 14 years old. And I really found that being the new guy, I tried to watch what everybody was doing. And Jim Seward was just a thoughtful, issue-focused listener. And I took away from that first time I met Senator Seward a great respect for him. He's a true gentleman, and it's an honor to serve as president in the wake of many very qualified people, and Jim Seward is one of those. So I'm going to. It is my honor. We're gonna do something that we don't do very often, but we're offering a resolution. This resolution is recognizing past President James L. Seward of New York as an honorary member of NCOIL. Whereas Jim Seward has served for over 30 years in the New York State Senate after being elected in 1986 and appointed as chairman of the Senate Energy and Telecommunications Committee. And whereas Jim has been a longtime active NCOIL member, having served in each of the NCOIL officer positions, culminating with his successful tenure as NCOIL president in 2009, currently serving as vice chair of the NCOIL Audit Committee. And whereas throughout his time at NCOIL, Jim has been at the forefront of several important NCOIL efforts, including being the sponsor of a resolution regarding reinsurance collateral requirements, out-of-network bounce billing transparency model act, resolution in support of health partnerships through Creative Federalism Act, NCOIL principles on healthcare reform, resolution opposing certain executive sessions of public policy officials, resolution in opposition to amending or repealing the McCarran-Ferguson Act, resolution in support of surplus lines insurance multi-state compliance compact, Slim Pact, resolution urging Congress to extend the effective date of non-admitted insurance provisions of the Dodd-Frank Act, resolution encouraging states to join an interstate insurance product regulation compact, resolution regarding the state's response to international proposals for insurer solvency regulation and global insurance capital standards, resolution in support of state insurance commissioner authority over fixed indexed annuity products, resolution in support of confidentiality of risk-based capital information, a resolution concerning amendments to the state liquidation laws addressing large deductibles. Whereas in addition to his efforts at NCOIL, Jim has led a prestigious career in the New York Senate, having served as chair of the Senate Standing Committee on Insurance, chair of the Senate Task Force on Voluntary Emergency Service, chair of the Senate Task Force on State and Local Emergency Preparedness following the September 11, 2001 attacks on New York City and Washington, and currently serving as ranking member of the Senate Finance Committee. And whereas, no matter in what role Jim has served, he has fought to develop policy that helps consumers and has always maintained responsiveness to his colleagues and constituents through personal contact, including district office hours, one of his greatest strengths and highest priorities. And whereas Jim has courageously battled through health challenges, including COVID-19, and whereas NCOIL legislators, staff, and participants have thoroughly enjoyed the hours we have spent working with, laughing with, learning from, and growing to know him as a great legislator and a great man. And whereas NCOIL's bylaws permit the NCOIL Executive Committee to, at any regular meeting, confer the title of honorary member on any individual who has served in a state legislature but is no longer a member of the state legislature and who the Executive Committee wishes to recognize for outstanding service to NCOIL. And now, therefore, be it resolved, the NCOIL Executive Committee recognizes Jim's outstanding service to NCOIL, and now further be it further resolved that Senator Jim Seward is hereby recognized by the NCOIL Executive Committee as an NCOIL honorary member to become effective upon Jim's retirement from the New York State Senate, and be it finally resolved and with great appreciation that NCOIL will send this resolution to Jim in honor of his special place in NCOIL history. That is a resolution. It is sponsored by Senators Jason Rapert, Assemblyman Ken Cooley, Senator Travis Holdman, Representative Matt Lehman, Representative Joe Fisher, Senator Neil Breslin, and Assemblyman Kevin Cahill. With that, Senator Seward, I know this is not expected. I hope it's a bit of a surprise. So
it is indeed.
We would love to hear some comments from the retiring Senator Jim Seward.
Well, first of all, Mr. President, and all the members of the Executive Committee, I'm really deeply honored by the resolution that's being considered today. And it's really an honor, and unexpected, but greatly appreciated. You know, I first became involved with NCOIL in early 1999. Most of you legislators were still in diapers at that time, but you know, in January 1999 is when I became chair of the Insurance Committee in the New York State Senate, and you know, I had never even served on the Insurance Committee in the Senate, but as circumstances would have it, I became chair at that time, and of course, I first heard about NCOIL when Bob Mackin, who used to at that time was doing the administrative function for NCOIL and based right there in Albany, our state capital. He visited my office and with a number of brochures introducing me to NCOIL and inviting me to my first NCOIL meeting in March of 1999 in Savannah, Georgia, which was, I fell in love with Savannah as a great city, but also fell in love with NCOIL as a wonderful organization. And as our Mr. President Matt has indicated in the resolution, I was very honored to serve as president of NCOIL through the year 2009, which was a tough year in many respects because of you know, we were in the middle of the financial crisis, particularly hitting the financial services industry as well as our whole economy, and it was a tough year for NCOIL. But you know, we continued during my tenure, and I was very, very happy to do so, and I felt it was very, very important to continue NCOIL's traditional stance in standing up very firmly and strongly in protecting, you know, state-based regulation of insurance. And during my tenure, we worked to expand, you know, NCOIL's commitment to educating our federal representatives regarding the strength of state-based insurance regulation, and also partnering with our sister state organizations such as the NAIC and the Governors Association and other state-based organizations, to all of us getting on the same page on that issue. And, you know, with promoting state-based regulation of insurance, of course, it's always important to try to approach insurance issues with some sense of uniformity and certainly recognizing individual state circumstances, but generally moving in the same direction in terms of insurance issues and legislations, as well as modernizing you know, insurance regulation as well. And so, as has been mentioned in the resolution, a number of model acts were adopted during my tenure as president. And you know, when I think about NCOIL, a very, very important organization for certainly the model acts that are provided through a process at NCOIL. It's an important organization to educate, you know, state legislators in terms of insurance issues. And also at the NCOIL meetings, that's a great opportunity to interact with all stakeholders as well as colleagues from around the country. That's an invaluable opportunity at the NCOIL meetings, I've always found. And just, I would close with this, you know, real hallmark of NCOIL as an organization. Certainly there have been changes and we've evolved over the years, but the real hallmark of NCOIL has been, you know, when an insurance issue is brought up and discussed at a committee meeting, and a model act is being developed, whatever the case may be, all sides of the issue are invited to present their views, which is invaluable to producing a good product from NCOIL. And also, NCOIL's a nonpartisan organization. You know, half the time I didn't know who was a Republican or who was a Democrat in terms of our fellow members of NCOIL, and that's as it should be, because that's another great hallmark of NCOIL. And I was delighted to work with, at that time, President Senator Neil Breslin, that we worked together in selecting Tom Considine to take over the administrative functions of NCOIL a few years ago. And I think that's proven to be a very good move for NCOIL, no question about it. So going forward, as an honorary member, does that mean I can still attend meetings from time to time? I hope so, because that's something I would greatly miss. But in the meantime, we've got some great New York involvement in NCOIL with former President Neil Breslin, and of course someone Kevin Cahill going through the chairs, and of course Assemblywoman Pam Hunter is taking on more functions, and of course Will Barkley has always been involved as well. So New York's going to be well represented at NCOIL going forward. So again, I'm deeply appreciative of the action taken today by the executive committee, but I also have appreciated the great association with NCOIL over the years. So thank you all very, very much.
Thank you, Senator. I know a couple of people want to make some comments, and yes, you are always welcome at our NCOIL meetings. There's always someone who needs to buy dinner, so you're always welcome to come back. So Assemblyman Cahill, Officer Cahill, if you want to make some comments.
Thank you, everybody, and I want to make sure everyone behind me is I'm trying to figure out how to get out of the way. Maybe I'll cover there we go. This picture was taken at an NCOIL meeting several years ago. Former New York State Insurance Commissioner Greg Serio saw Jim and I having our usual back and forth, which he came over and noted. He said, you know, you would never know you guys were from opposite parties. You get along so well. And I said, oh, Greg, that's not acceptable. Can you take a picture so we can bring it back to Albany and show them what we really do at NCOIL? So this picture is what we took. And it graces the book cabinet of my desk to this day, and is of great interest to people who come in my office. They say, boy, you really didn't get along with Jim, did you? I wouldn't have taken that chance with anybody else. He is, Jim, you're a true gentleman. I have never been said no to so nicely so many times by one individual as I have by you when we negotiated between the Assembly and the Senate. As Neil and I were saying before this meeting began, we don't have you to blame anymore for the stuff we really don't want to do, but our conferences do. So we have to take that hit. It has been a pleasure serving with you. It has been a pleasure getting to know you and getting to know Cindy and hearing about your family. It has been a great honor to share communities that we represent together, some of the more rural parts of my district, but certainly the most urbane part of yours. The coincidence of our sharing a district and sharing responsibilities for insurance in the Assembly proved to be good for the people of New York, and made all that we had to do a much greater pleasure. I want to thank you for your years of service to the people of New York State, to the New York State Senate, to make sure that you were probably my best teacher when it came to insurance. I learned pretty much everything at your elbow, and a very sharp elbow sometimes, but it was a great honor to learn from you. Jim, you helped contribute to my love, and not just mine, but Pam's and Andrew's and Will's, and even Rob Orton, who's now the leader of the Republican Party, came to one of our meetings because of you. And of course, watching your partnership, not just here in NCOIL, but back at home with Neil, has been a lesson for all of us. It's difficult for outsiders to know who the chair of the committee was, because you two got along so well and shared so much. You will be missed in the state legislature. I hope I see you around town here and there, but certainly we'll make it up to Cooperstown, and we hope that Lyconi makes you an honorary member there as well. So, Jim, thank you for all of your service.
Thank you, Kevin, very much. Thank you.
Thank you, Kevin. Senator Breslin, you want to make a comment?
Yeah, I certainly do. First of all, you mentioned that we're so nonpartisan here at NCOIL and don't know what Democrats and Republicans. I've never asked you, what party are you in? I think we should all laugh because the better part of 2 decades, Jim and I have been either the chairman or the ranker on insurance in New York State in the Senate. The better part of that time was spent, I was the ranker and Jim was the top person. And during that period of time and throughout those 20 years, I don't believe that Jim and I have ever had a serious conversation or gotten mad at each other.
No.
And it's, I think it's interesting, and I think it's a good object lesson that I tell some of the newer members in the Senate. I'm probably labeled as by Jim as a liberal Democrat. I think of Jim as a conservative Republican. Yet on insurance issues, our points of view rarely varied. And I know that I have learned so much from Jim. I've learned so much from Jim, not only on insurance, but how to conduct yourself. And how to conduct yourself is so important. We have a lot of new senators right now who, woke up on third base and thought they hit a triple. And they know more than you the day they get here. And Jim has always shared with me his beliefs on particular parts of points of legislation and has listened to me, albeit I don't think you convinced many of the members of your conference to go along with my point of view. But it was to me, you were a great example of what a legislator should be and what an elected official should be. Your knowledge of insurance, your humility, your ability to get along with both sides of the aisle, to me is one of the most wonderful memories of our relationship, which I hope goes on forever.
Absolutely.
Your bride and I have had a wonderful relationship during that period of time, and we love Cooperstown, which we showed Cooperstown to George Kaiser.
Right.
And a lot of people, when they come to New York, they think of New York City. They don't think of the beauty of Cooperstown. But Jim, I can't thank you enough for everything you have done to make me a better person, to make me understand how you should be as an elected official. And I might add that Jim just said earlier, oh, you're in your office, aren't you, Neil? Well, he probably knew that because this used to be his office.
Yeah, that's true.
I've been looking around for pots of gold around here. I haven't found them yet. So, but Jim, let's continue our relationship. You're my leader, and I continue to respect you and enjoy a wonderful friendship. Thank you.
Thank you, Neil. That's very touching.
Thank you, Senator Breslin. We are pressed a little bit for time, but if there's anyone who has a brief comment yet, I would open that up. I do think we could probably go on and on recognizing Senator Seward. And again, thank you, Senator Seward. And on that note, I would ask for a motion to adopt this resolution.
So moved.
Is there a second? All in favor will say aye.
Aye.
Opposed? Unanimously passes. Thank you again, Senator Seward.
Thank you.
I'll move on to the next item on our agenda here, update on future meetings. Tom, you want to update us?
Thank you, Mr. President. So our spring meeting, as we sit here today, is in Washington, D.C. Now, we just need to be aware that Washington, D.C. has a meeting limit of 25. As the vaccine rolls out, we're going to stay in contact with Washington to see if that limit moves up to 100 in-person attendees, and then we'll see what happens. If not, though, we would have to look to other alternatives. We've already let the legislators in Maryland know that if they were to pay their dues, then we'd consider Annapolis or the Inner Harbor. We're not limited to that specific area, though. New Mexico has been pressing very hard to get us to Santa Fe. They have paid their dues, so more to come on this. I don't know if Santa Fe is too difficult to get to for a March meeting with people in session. I'm hearing probably and nods. The remainder of the meetings next year, summer is right across the border from you, Senator Seward. So you could just head right over and see us at the Westin Boston waterfront, and you'll be there in your honorary capacity right then. And we can't look forward to seeing you more. And then in November out in Scottsdale. So we look forward to that. Additionally, we spoke at the last meeting about San Diego for the spring of 2023. We've now pretty much narrowed that search to the Westin in the Gaslight district of San Diego. You know, there's a ton of activity there in the Gaslamp Quarter, and the Westin was recently renovated, so everything is a go for that.
All right, thank you, Tom. There'll be obviously more to come on that. Let's move on to the next item, which is administration. Tom, if you want to give us a report on the meeting and our financials.
Sure thing. Thanks. So we have 246 attendees and participants in this annual meeting. 60 of those are in person. We would have gotten a room a little less large, but certainly there were no virus moving around between people in a room this big. For those of you on Zoom, this room is about the size of 2 football fields that we're in. There were 186 virtual attendees. We had 37 legislators from 21 different states. 14 attended in person, 23 virtual. 2 of the legislators were first timers. We had commissioners from 4 states participate, 1 in person and 3 virtual. On the financials, we're having a strong year financially. The unaudited financials through November 30th show revenue of just over $1,200,000 and expenses of just over $912,000 for an excess as we head into this meeting for $315,626.50. We may take a little hit on this meeting, though. That's all I have, Mr. Chairman.
All right, thank you, Tom. We do need a motion to approve the administration report. Do I have a motion?
So moved.
Is there a second?
Seconded.
Okay, I'm sorry, Ken, I wasn't looking at the screen. All in favor, say aye.
Aye.
All right, we'll move on to our next item, which is our consent calendar. These are committee reports, including resolutions, model laws that have been adopted or readopted therein, as well as ratifications of decisions made and actions taken by the NCOIL officers in the time between our executive committee meetings. I think you've been furnished with that list. Is there any committee members who would like an item removed from the consent calendar? Hearing none, I need a motion to approve as a block the consent calendar. Is there a motion?
I so moved, Mr.
Second.
President.
Second. All in favor will say aye.
Aye.
Next item is I'm going to touch on a couple of the other sessions that we had. During our discussion of the PREA and the federal-based business interruption. We were honored to have Congresswoman Carolyn Maloney Zoom with us on that to give us an update on what's happening in DC on that. We had a legislator luncheon examining the insurability of a pandemic. I want to thank Dr. Lawrence Powell, who did that, as well as was one of our panelists. Just kind of double duty this conference. We had, I think, 3 very interesting and timely general session discussions. Bitcoin and beyond. What is this stuff? And I still have to think, I'm not sure what it is. So I think we need to maybe do that one again. It does challenge us to look into some of that more frequently. Our health general session, again, also very timely on the federal health care, the Supreme Court decision that's coming, the new administration coming in. And I thought our speakers on that, Professor Gluck and Dr. Pope, were excellent. It was a very good discussion. We just wrapped up an innovation on medical cannabis. Again, another issue that is very timely and in our states. Thank you for all that participated in that. We also held on Wednesday First meeting of our Special Committee on Race and Insurance Underwriting. Again, a thanks to Senator Breslin for bringing that all together and doing a great job in chairing that. I do want to applaud everyone who participated in that. I thought we had a really good discussion and a lot of data to go through as a result of that. At this point, I will open the next item on the agenda is the nominating committee report. I'll turn to Senator Holdman for that.
Yes, thank you, Mr. President. We have had quite a bit of discussion about filling the nominating committee slate for 2021. And it was the consensus of the group and action taken by nominating committee to nominate all of the current officers to return for another term in 21 due just to the nature of business activity and the activity of the state legislatures throughout 2020. It just seemed appropriate and not inappropriate to ask the current officers to serve one more term. I know this has been the model that has been adopted by several other national associations, and we feel that it's an appropriate action to take. Had conversations just this week again with Senator Rapert, and he had to leave early or else he would have been here to assist in giving the report. But Mr. Chairman, or Mr. President, excuse me, at this time, I would move the adoption of the nominating committee report, which is that all of the current officers be retained for 2021.
This is Ken Cooley. I second that motion.
So we have a motion and we have a second. Is there discussion?
I'd like to just indicate that I think it's a great idea. I think that it's been an abbreviated year. We have competent officers who haven't really gone through the full year, and it's going to be another difficult year. And I trust the existing officers to do a phenomenal job helping us pull through this pandemic. So I applaud the idea, Travis, for bringing this to the committee, and I vote in the affirmative.
Thank you. Senator Cahill, comment?
Yes, ladies and gentlemen, thank you for recognizing me. I am not in support of this motion for the following reasons. I certainly respect the individuals involved and treasure the leadership that you've provided, particularly Matt, through what may be the most challenging year organizationally that NCOIL has had to face, given the nature of the uncertainty of our ability to meet together and the putting together of a brand new paradigm of how we were going to organize our meetings. But I need to point out that although nothing in our bylaws specify that the leadership of the organization should change parties on a regular basis, it has been the longstanding tradition of this organization to do just that. However, for the last 3 years, we have had, all due respect, leadership from the same party. 4 of the last 5 years, we have had leadership from the same party. And while the comments of my colleague, Senator Seward and Senator Breslin are absolutely true, it is difficult most of the time to discern the political affiliation of the membership of the party. It does have subtle impacts, and it also affects our ability to continue to attract people from the public, from those legislatures that do not yet participate or do not fully participate. And it is important, particularly given the fact that certain organizations of state legislators have developed reputations of being something other than representative of the 50 states, that we continue to maintain that tradition. I would also take issue with 2 other things. One is I don't believe that there's any impediment to us continuing to advance leadership as we have in the past, nor do I believe that this has been in any way an abbreviated year. We've conducted business completely, fully. We've had all but 1 meeting with very significant, in fact, predominant attendance by most members and other participants. And we've moved legislation, model legislation, and other matters significantly along the way. I think that it is important to keep that tradition going. I do recognize that that the executive team is balanced, but quite frankly, as we all know, the tenor and tone of the meetings are embodied in the president of the meeting. And while the motion was made by the person who would likely have been elected as president the next time, Assemblyman Cooley from California, I still would differ with the concept that we not rotate the parties. Last and certainly not least, the nominating committee, I believe, was not properly impaneled. I believe that there are rules in our standing rules that would prohibit any of the nominees from participating, yet nominees did participate. All officers were not invited, some officers were invited. I would not have in any way thought that I could have been persuasive in that meeting, but I would have liked to have an opportunity to raise the issue in that meeting, and I was denied that opportunity, while people who take the opposite point of view were given that meeting and allowed to attend, in spite of the fact that there is a rule against participation by people who are being nominated. So with that, Mr. Speaker, Mr. Chairman, excuse me, Mr. President, I'll get your title right in a second. I understand that I will probably be a lone vote here today, but I did want to make sure that I registered my point of view. Having done so, let me reiterate that this is no reflection on your leadership, which I value greatly, and look forward, in spite of my vote in the negative, to your continued leadership.
All right, thank you, Assemblyman Cahill. Is there further discussion? We have a motion and a second. All in favor will say aye.
Aye.
Opposed?
Nay.
Nay.
So we had, according to my ears, I'll say that was a majority. Again, I appreciate that. None of us went into this year anticipating this. And I want to first of all say that I want to thank my fellow officers, Ken Cooley from California, Kevin Cahill, and I know Kevin. You said it's not me, and I would say I none of us asked necessarily for this, and I have great respect for Assemblyman Cahill. He has been good to work with, and we will continue to be strong partners as we move forward. And then Joe Fisher from Kentucky, our newest member, will continue. And I just hope, I guess what I look forward to in the next year is to put a rough year behind us. This hasn't been easy for our states, for our communities, even for our families, and especially for NCOIL. Again, when we met a year ago, we sat in a room with 300 people or 200 people, and I'm sitting in a room today with about 12. We long for the day that when we get together, those debates aren't held over technology, but they're held face to face. I think Senator Seward, when he talked about the ability to debate and discuss and even differ, we need that as an organization to be face to face again. But I'm very positive of the future. I think we're focused on good public policy. I think if you look at what we're putting on our agenda, starting with our addressing timely issues like race and what's happening in the business community with liability, I think NCOIL is poised to again be a strong focus this next year. And I guess I just look forward to a really good 2021. I look forward to be able to meet, to be able to shake hands. You don't realize that, but the number of times we've not been able to shake hands and pat each other on the back, and I'm just looking forward to that. And I think we can and will be able to get back together. And I've already heard from Senator Seward that he's willing to buy all of us dinner when he comes back as an honorary member. So looking forward to that. Looking forward to a difficult year ahead of us, but with the help of my fellow officers, we will become strong. I'd be remiss if I didn't say. Really want to thank Will and Tom and their staff. Like I said in my opening comments, I've never gotten so many calls from New Jersey in my life. That will continue, I know. And then I can't wait for the day I can block those calls and move on with my life. But it's an organization that I think has been strong and is getting stronger. And I really do look forward to working again with Ken and Kevin and Joe to make NCOIL even better in 2021. So thank you. All right. Any other business? We got a couple of things maybe yet to clean up. Consideration of an audit. Tom, you want to fill us in on that?
Sure. Thank you, Mr. President. And I look forward to calling you at least 365 times over the next year.
That'll be less than this year.
So the committee approved the audit at our last meeting. This is about retaining the audit firm, Collins and Company, for another year. It's a small firm. This is their specialty, not for profits. We got them because they do a number of guarantee associations and a number of insurance associations. As a small firm, they can't really rotate audit partners, but however, they do rotate the staff that works on the audit. They do a fine job, and I would just request a motion and a second and approval to retain Collins and Company for another year.
So moved.
We've got the motion and a second. All in favor will say aye.
Aye.
A couple of things of business to touch on here. We have a couple of new, we'd like to welcome, as per our bylaws, a couple of new executive committee members. West Virginia Delegate Steve Westfall, Indiana Senator Andy Zay, as chair of their state's insurance committees. By our bylaws, they're automatically NCOIL executive committee members. The IEC general session topic recommendations, I believe, is Frank. Are you on the Zoom call?
I am, Mr. Chairman. Thank you.
All right, I'll turn it over to you for your recommendations.
Thank you, Mr. Chairman. And if I may, for just one moment, just on behalf of the IEC, we also want to thank Senator Seward for his leadership, his wisdom, and we look forward to seeing him in his new role as an honorary NCOIL member. It's been a pleasure working with the senator. Mr. Chairman and members of the committee, IEC has one topic to present for NCOIL for its consideration as it prepares the agenda for its next meeting. The topic submitted by State Farm and NAMIC relates to some regulations that can slow down claims processing in the wake of a natural disaster. In such situations, both carriers and their policyholders both have the same interest. They want to get claims paid quickly, get claims paid fairly, and we would like to explore with NCOIL some ways to increase the efficiency in terms of this process, particularly for smaller claims, while at the same time protecting consumers. And this is something that, again, is right in NCOIL's wheelhouse. I would point to the actions that NCOIL has taken recently with the Model Act regarding the protection of settlements involving minors, which balance flexibility with consumer protection. So with that, Mr. Chairman, I put that to NCOIL's consideration for possible inclusion at the next meeting. And I'll also be happy to answer any questions. Thank you, Mr. Chairman. That concludes my remarks.
All right. Thank you, Frank, and we'll make a note of that. Appreciate the work I do that IEC has done in bringing some of these issues to us. Looking at my agenda, I don't see anything else that needs to be brought forward. Is there any other business to come before the executive committee today? Anybody on Zoom have an issue yet? Seeing none, we'll take a motion to adjourn our annual meeting.
So moved.
Second. All in favor will say aye.
Aye.
Opposed? I guess, Senator Rutke, you got to go back to 21-degree Minnesota. All right. Thank you, everybody.